Assalamualaikum and a very good day. I bid to Dr. Mukris. Today we will give an explanation regarding the basic information about trial proceeding and also provide example of questions to enhance the effectiveness of giving court testimony on behalf of the legal department of Ministry of Health. I'm Muhammad Akmal Imran, one of the legal advisors, and allow me to introduce my team members. The legal advisors team consists of Nur Hanum Zaki, Zinirah binti Muhammad Nur Aina Kamila binti Zalizan, and Kodi Suntraraju. Without further ado, let us start our presentation for today.
Hello doctors, we are from the Legal Department of Ministry of Health and we are here to provide you with the basic information and guidelines before stepping into the courtroom to give testimony as an expert.
One of the main forms of evidence in the court of law is usually a testimony of witness. A witness is a person who gives a sworn testimony in the court of law. Testimony is a formal written or spoken statement, especially given in a court of law. Expert evidence, meanwhile, is a testimony given by expert witnesses. An expert witness is therefore a person who is allowed to give their opinion in the court of law because of their knowledge or skills in a particular subject. They are providing the court with a statement of opinion on any matters calling for their expertise. The rule permitting the reception of opinion of expert is set out in Section 45 of the Evidence Act 1950. There are no specific rules as who may testify as an expert. Expert witness, however, must have a sufficient knowledge and practical experience before placing the evidence in the court. The expert must acquire their expertise in the relevant field of education, training, or experience. It is up to the judge, nonetheless, to decide whether a person is qualified to testify as an expert. And when an expert is being called when the issue is beyond the common knowledge or an experience of a judge. Therefore, when you are being called by the court to give your expert opinion, your testimony as an expert witness will ensure that the court can properly assess the evidence or determine how much weight to give to the evidence. Besides, for your expert evidence to be admissible, the evidence itself must be reliable. Your expert opinion evidence must be derived from a reliable scientific basis. Your expertise must be part of a body of knowledge which is sufficiently recognized to be accepted as a reliable body of knowledge. The reliability of the opinion evidence will also take into account the method used in reaching that opinion, such as validated techniques and technologies. It will also take into account the process used in analyzing the evidence, whether the processes are providing sufficient scientific basis for the expert to form a conclusion. As the expert, you also must provide the court with the necessary scientific criteria to test the accuracy of their conclusion.
How an expert shall give testimony in court. You must answer the questions in plain language. The expert witness is called to the court to interpret, clarify, and express opinions about the facts. The case of Chu and Chun and others against Profound Gay with Sendian Berhad provides that the general rule is that an expert is to assist the court. The expert witness role is to provide assistance to the court in understanding the facts in issue involving his area of expertise. You are advised to avoid using medical jargon and clarify in simple terms to the court. Next, you should answer what is asked. An expert witness is brought to the court for a specific reason. You should provide a clear answer to the questions in regard to your specific expertise and shall not provide answers to those that are not in your area of expertise. Only provide extra clarification if necessary. And you should provide an unbiased opinion. If you look at the case of Poverty against Commercial Union Assurance Company, it explains that an expert witness shall provide independent assistance to the court by way of objective, unbiased opinion in relation to matters within his expertise. First, one of the questions that you as an expert witness will be expected to answer in trials is in regards to your background. For example, please state your name, your occupation, and where you are currently working. This is based on the following questions that were presented to the expert witness in the case of Mat Sidik Salib and another against Rosli Abu Hassan, which were, sila nyatakan nama dan alamat tempat tinggal anda. Boleh beritahu kepada mahkamah apakah jawatan anda dan di manakah anda bertugas sekarang. The question entails the expert witness to affirm the identification and background as to prove to the court their relevancy as to be involved in the trial. This will affirm the court on your involvement as the expert witness in the trial. In the case of Salim Saisha, the expert witness had stated that the background and experience to the court. Second, another question that you'll be expected to answer in trials is on your qualifications. For example, the questions would be, what is your educational background? What degrees, certificates, or licenses do you have? In order for to A Rule 3 subsection 2 subsection A of the Rules of Court 2012, it states that an expert's report shall give details of the expert's qualifications. The rules that govern the proceedings of the court provides that in order for an expert evidence to be admissible in court, it must be corroborated by an expert opinion, and the expert witness must give details of the expert's qualifications. You are required to answer these questions to establish that you are indeed an expert witness on the issue in question. In your case, you are required to state your qualifications in the medical field, including your education, housemanship details, medical license, and so forth. We can refer to the case of Wong Chop Sao, where the court explained that, first of all, the expert witness should first state his qualifications as an expert. Establishing your qualification would avoid the expert opinion from being challenged by the opposing party, which could lead to the dismissal of the expert opinion and expert evidence.
That usually you would be expected to answer question in trial regarding your specialization. Examples of the question would be: what is your area of specialization as a doctor? How many years of experience do you have in your field of expertise? As in the case of Dr. Kupu Permani, all of the medical expert witnesses had stated their area of specialization and years of experience they have in their field of expertise. This is done to make sure you are truly an expert and to establish that your knowledge goes beyond what the court already knows. It also helps you prepare for more specific questions that only someone with expertise in that field would know how to answer. For instance, they might ask you whether a person's death was caused by poison or if certain symptoms indicate a mental health issue. Or other question usually being asked in trial is regarding if you had interest with any of the parties involved. Example of the question would be: are you currently involved in any professional or personal relationship that could potentially create a conflict of interest in this case? This question usually being asked to avoid your opinion cannot be relied upon since you had interest with any of the parties, and it is also as a reminder for you to disclose to the opposite party regarding the relation. But still, it is up to the court to decide either to accept or reject your opinion. As in the case of Hospital Assunta and another, it was held that the doctor had an interest in the decision to favor the second defendant, and his opinion could not therefore be relied upon. Fifth, next question usually being asked in trial is regarding course or seminar attended. Example of the question would be: have you attended any course or seminar related to your area of specialization as a doctor? This question usually being asked to reaffirm that you are totally an expert which is suitable to be the witness in the trial, since there is a situation where specific training is necessary.
The sixth point is the court would ask the expert witness regarding the proceeding prior to the current one. One example for such question would be: do you ever as an expert submitted evidences in other similar cases prior to this proceeding? And this question is asked to inquire about the expert witness experience in previous court cases that are similar in nature to the current proceeding. By understanding their prior involvement in similar cases, the court can assess the witness qualification and expertise in testifying for the particular type of evidence at hand. And this question reinforces the importance of the expert's opinion by highlighting their relevant experience. And lastly, you must also expect to be asked on the works published by you that has been made in the making of the said evidence. For example, do you publish any works in regard to your opinion about the evidence? This question aims to determine if the expert witness has published any research, studies, or papers that specifically pertain to the evidence they are offering an opinion on. It establishes the expert's credibility and demonstrates their depth of knowledge in the subject matter. Secondly, does your published works be known to the public, or does the public are aware of your work? The question seeks to assess the level of awareness and recognition of the expert witness published works. It helps strengthen the credibility of the expert's opinion by indicating that their work is known and respected within their field, making their expertise more valuable to the court. Other than questions mentioned before, there are still questions that will be asked by the court, such as: on what did you base your opinion, and please state the specific data on which the expert relied. And this question is expected to be asked by the court to understand the foundation of the expert witness opinion. And by asking for specific data and information sources, the court can evaluate the reliability and validity of the expert analysis. It allows the court to assess the methodology employed by the expert witness and the evidence on which their opinion is based.
When it comes to expert opinion, there are some issues as to the application of it due to its need for expertise in the field relevant to the matter of dispute. Firstly, issue may arise on determining whether you are an expert and when to apply the expert opinion. Determining whether someone is an expert typically involves a combination of knowledge, experience, and demonstrated proficiency in a subject area. We may refer to the case of Junaidi bin Abdullah against VP. The question is whether the evidence required particular expertise and whether the witness had a formal education and practical experience in that field. Academic credentials and real-world experience help them make a more informed decision. Secondly, there is an issue conflicting expert opinion. When there are two different opinions in the court, the judge or the jury needs to look at the opinion of the both party together and consider them as a whole. In the case of PP against Dato Sri Anwar Ibrahim, the court found that the defense expert were unreliable because they relied on just books and journals rather than real-world experience. The court considered the prosecution experts' arguments and evidence more convincing. Thirdly, probative value of expert evidence. An expert's opinion won't be more valuable than direct evidence if it contradicts reputable witness or powerful documents. Referring to the case of Sheikh Abu Bakr bin Ahmad against PP, you can see that if the court cannot make a fair decision without the help of an expert witness, they must ask expert to provide evidence and information about the specific matter.
In simpler terms, if the court needs the expert knowledge to make a more proper judgment, they will ask the expert to give evidence about that matter.
In short, you as the expert must also offer opinion evidence which is related to your field of expertise, or have to provide an opinion which is relevant to an issue in the case. Otherwise, your opinion as an expert will be inadmissible. Your main duty as an expert witness is therefore to providing the court with reliable opinions and evaluation based on their analysis of the evidence. Hence, as an expert witness like you can be a great assistant to the court in aiding them to determine the issue in a case, including the guilt or innocence of the accused.
That's all from us. Thank you and good luck.